How should SCOTUS rule in Donald's presidential immunity case? First of all, SCOTUS should do so fast. And by fast, I mean within the week, or if they do it in their version of expedited, 3 weeks. Whatever the case may be, the Supreme Court has a responsibility to rule on this case fast, because every day that they don't rule on this case, they are delaying a federal criminal trial of unique importance and going against their own ruling that the public has a right to speedy trials as well. It's not just the defendant. So with that said, welcome to Law and Society. What I'm going to do now is read to you something that I have written that I believe should be what the Supreme Court rules in this immunity case. So here we go. Both parties agree that there are certain core executive powers that are unreviewable. Those powers and actions taken stemming from those powers, like pardon power, veto power, recognizing foreign nation, and making appointments, are not at issue in this case. Both parties also agree that presidents and former presidents have no presidential immunity from private acts. Petitioner conceded that portions of the underlying indictment in this case involve private acts, while maintaining that some of the acts alleged in DOJ's indictment were unreviewable official acts. Private acts do not enjoy presidential immunity. When such private acts are commingled with official actions, however, the fact-finding court must, before the trial can proceed, assess whether alleged acts were primarily private or primarily official. Primarily official acts have no private aim or purpose, and they enjoy presidential immunity. But primarily private acts involving private persons working together towards a private end enjoy no immunity, even if done under the color of POTUS's official duties. Those acts committed under the color of official duties only help further a private goal. In this case, that alleged private end goal was to use fake electors to change the electoral vote count, defy the will of the people, and remain in office despite having lost the 2020 election. Surely, those alleged actions require proper judicial review. The case is remanded for the trial court to hold a fact-finding hearing to determine whether actions alleged can be prosecuted under the framework provided. If the fact-finding court finds that petitioners' actions were private in nature, conducted with private people, and towards a private end, any official actions undertaken in furtherance of those private ends do not enjoy presidential immunity, and the criminal trial can proceed. So that's what I think that the Supreme Court should rule in this case, because that's what the petitioners themselves conceded, that the indictment had several private components to it. So I will leave you with this, and I'm hoping that this is akin to something what the Supreme Court will say, that it will provide a test that the lower district court can apply for an evidentiary hearing to be able to determine whether they were private acts primarily or official acts primarily. And if they were private acts, official acts taken in furtherance of those private acts are not covered by presidential immunity, because all they did was to amplify and to facilitate private ends, that being defrauding the United States, its people, obstructing justice, and conspiring to do so. So with that said, thank you so much for being here, and I will talk to you soon.